Hello, YouTubers. My name is Ismail Shakhtakhtinsky, and I am the principal immigration attorney at I.S.Law Firm. I hope everybody can hear me well. If you can please post in the chat section, I'd greatly appreciate this if you can hear me well. Okay, so today is the next live session on English language YouTube channel, and I will be answering questions as much as I can. If you can please post your questions. I see some of the questions already posted by admin from our YouTube channel and Facebook page. And if you can post your questions in the chat section, I will answer as much as I can. If you can please also press thumbs up and subscribe to our channel, would also greatly appreciate this. So again, if you're watching this live stream, if you can hear me well, please post in the chat section if you can hear me okay. My name is Ismail Shakhtakhtinsky, and we will begin here. So in today's video, I want to talk about the current asylum processing and answer questions about asylum and any other immigration questions if you can post in the chat section. I will also tell you about the new information for border processing for those individuals who arrive through the southern border into the United States. So as you all know, currently there is a process of crossing the border through legally and lawfully through an app that you can download on CBP's website. It's called CBP One. If you register through app CBP One and you enter the United States lawfully, you will be paroled. You will be able to apply for work permit in the United States immediately. You don't have to wait for your asylum case to be filed and then 150 days, but you can file immediately. But the news is that the Biden administration announced is that if you enter the United States through any other means other than through CBP One app, for example, if you cross the border illegally or just arrive at the checkpoint and apply for asylum without making an appointment, then you will have a potential ban for asylum because you crossed through other countries. It's called third safe country ban. I don't remember the exact name of this ban. But in any case, what it means is that you will have to demonstrate that there were compelling reasons why you could not and did not apply for asylum in those countries through which you passed on the way to the United States. Now, if you go through CBP One app, then you don't have to prove this. You still have to prove that you went through CBP One, you downloaded it, you made an appointment with the CBP officer, and that's how you entered the United States. And therefore, it will be much easier process for you if you enter the US lawfully using the CBP One app. And the reason why they're doing is they want to create some kind of order so that the southern border is not overwhelmed. There are no illegal crossings, apprehensions, that the CBP officers don't have to detain individuals and so on. If you do download the CBP One app and register and make an appointment and enter the United States through that process, it's highly unlikely that you will be detained. You will not be detained. About 98%, according to statistics, of individuals entering through this process are not being detained. They are being briefly held for questioning, for document verification, and then they're placed in a hotel, usually hotel, motel, or whatever that is. It's not a detention center where you're processed while you're being processed, and then eventually you're allowed to enter the US with parole. Then the CBP issues a notice to appear in court, gives you 9-digit file number, and the document, which is called notice to appear, will have a date for the court, for your court hearing, and place for your court hearing. However, that date for the court hearing may not be accurate. They have to indicate it under the law, But what they also have to do is file the same document with the immigration court, and the immigration court will open your case and schedule a new hearing date. There is a website. We'll put the link of that website, EOIR case status. If you Google that, EOIR case status, you can put your 9-digit file number, which is usually on the top right of that document you receive at the border, and you can see if you have immigration court dates scheduled, date and time and place. And you will be also able to see your immigration judge's name, and you can look up this statistics on the approval and denial rates of that immigration judge that you have. If you move to another state from the state where you initially were intending to go to, based on the whoever sponsor you had in the US, then you can file, and you should file, change of address with immigration court. And you have a right to request for your case to be moved from that state to the new state, to the new immigration court. Now, there is important nuance in doing so, in that if you request to change the venue, that's called change of venue, to change your court, then you are delaying your asylum case processing. And what it does is it stops your asylum clock for the purposes of EAD, Employment Authorization Document. So in most cases, it's not advisable to request change of venue until either your 150 days pass and you apply for EAD, or if the government, the other side in immigration court, requests the change of venue on their own. In some circumstances, in some cases, we also, depending on the jurisdiction to which you move, we recommend our clients not to request change of venue at all, and request the court where your initial case was assigned to review your case without having it moved to another court. That could be, strategic decision based on the court and jurisdiction in which you're going to have your new hearing based on your current location. So this is the new information. As I said, they do detain individuals who don't enter the U.S. without the CBP-1 app. They also apply this third safe country ban, where you should have applied for asylum if you do not use the CBP-1 app. The other information I have for this week is that it relates to those who have been granted asylum and are planning to apply for permanent residency. So at one point in February, the USCIS announced a new policy that that asylees, those individuals who applied and were granted asylum, can apply for permanent residency even before they accrue 1 year of physical presence in the US. But in that announcement, the USCIS also indicated that they're changing this policy because some of the applicants travel before they're granted permanent residency, before they apply for permanent residency, and from after being granted asylum, they travel abroad, and that's why they lack several days or maybe weeks or months of physical presence. And that was very confusing because the USCIS in their initial announcement was differentiating the calendar year. It was indicating that as if there are two requirements, 1 year of physical presence and 1 year of calendar year of waiting before you can apply for permanent residency. But now they somewhat clarified it, and it became clear that under the new policy, asylees, meaning individuals who have been granted asylum, they can apply for permanent residency even the next day after they are granted asylum, because the process of permanent residency takes about more than 1 year. So by the time the officer looks at your case, you are expected to have sufficient physical presence in the US. Now, I do want to caution everybody, if you apply immediately and your case is reviewed within less than 1 year, or if you travel outside of the US before your case reaches an officer for review, for what they call adjudication, then you may have your case denied. So typically, therefore, we recommend our clients now, based on this new policy, to wait at least 6 months after the grant of asylum to apply for permanent residency. I wouldn't say at least 6 months, because I just today I was talking to some of our clients, and I recommended to file even now. They've been granted asylum, 4 months, 5 months ago, at least to start the process of putting the adjustment of status case together. So I'd say anywhere around 6 months waiting time after grant of asylum to apply for a green card is a good idea. So this new policy, it makes substantial change. It helps the asylees to become permanent residents faster than it used to. And it also helps them, obviously, to become citizens down the road much faster, to be able to sponsor their relatives, to bring their parents, for example, into the U.S., and, just the benefit of becoming a U.S. citizen faster. So that's very important change in the policy, and I encourage individuals who have been granted asylum or who will be granted asylum in the future to consider applying for permanent residency, within the first 6 months. You don't have to wait 1 year. So for those who just joined this live stream, I do want to repeat, I briefly went over the changes in the asylum processing at the border, and please post your questions in the chat section. Any kind of immigration questions, I will do my best to answer as much as I can. And please press like and please subscribe to our channel. I would greatly appreciate that. Okay, so I will start with answering some of the questions that are already posted, but again, I encourage everyone to post any questions you have, and I will do my best to answer as much as I can while others are joining. All right, so the first question I have is, Oceanics Prints asks, I filed my asylum application 1 day after I finished 1 year. Will it be a point for a weak case? The answer is yes, unfortunately. There are many exceptions. There are many circumstances, where you can be excused from 1 year deadline, but I'm sorry. So how to, there may be excuses for 1 year deadline, but you have to be careful. So I cannot give you an answer now without knowing all of the details of your case. But the important part is, the important nuance is, if you mailed your application and you have proof that you mailed within 1 year, then you're good, you're covered, because under the statute, under the law, that falls under the exception. Okay. So the next question I have is, can I request asylum if I stay in Africa for CBP1? You cannot stay in Africa for, well, I mean, you have to be physically in Mexico to be able to download the app and to register with CBP1. You cannot do it while in Africa. That's not going to work. Next question is, my asylum is pending. If I marry the USA citizen, can I be eligible for green card? I came here border cross, thanks. Well, border cross can mean many different things. If you cross the border, what we call without inspection, meaning you cross the border illegally without an appointment or not through the checkpoint, then you are out of luck. Unfortunately, you cannot adjust your status in the US. You may have an exception if you file a waiver, and you will be able to go through US consulate abroad if you are eligible for a waiver of unlawful presence. But without knowing all of the details of your entry and of your case in the US, how long you've been, which country you're from, there is no way for any of us to give you the full answer to your question. Again, guys, please post your questions in the chat section. I will do my best to answer as much as I can. And in between, I will also talk about, the process of applying for asylum, the evidence gathering. I made a very long and detailed video on gathering evidence, the types of evidence for asylum cases. That video will be posted on our YouTube channel. It's almost like 1 hour video where I broke it down to great detail as to how to gather evidence, what kind of evidence, what can you provide as evidence for your asylum case. So please subscribe to our channel so you can be informed and please hit that bell sign so that you can be informed when that important video is posted. I've been promising it for a long time to make this video about evidence for asylum cases. And as I said, I just did it yesterday, so they're working on editing it. And once it's ready, it will be posted on our channel. So please subscribe so you can be informed when that video gets posted. It's very helpful, very important. It's about preparing your evidence, asylum application, including in the beginning and at the same time prior to your asylum interview or your asylum hearing in immigration court. All right, so next question I have is Deep Quotes is asking, will I be allowed to work at other jobs besides my job with the employer? I don't understand the question. Depends on the type of visa or employment authorization document you have. If you have a work visa, for example, H-1B, then you're limited to the employer that you have. If it's just an EAD, employment authorization document, for example, based on the pending asylum case, then you can work for any employer. My name is Inacinho Lobo. I need some help. My Indian passport expired 16th of December 2023 and my visa already expired. But I want to renew my Indian passport. Well, yeah, okay, I understand. You can contact the consulate of India here in the US in Washington, D.C., and maybe they can help you with renewing your passport. Unfortunately, I cannot help you with renewing your Indian passport. Your visa already expired. That means you're not lawfully present in the US. If you're an asylum applicant, you don't need a valid passport. You don't need to renew passport, and we don't recommend renewing your passport. Anytime you renew your passport, your country's passport, while you're waiting for asylum in the United States, then that is negative factor for your case, because you're saying that you cannot return to that country. You are being persecuted by the government or groups, individuals that the government supports or is unable, unwilling to control, and at the same time you're renewing that passport. So that creates a negative inquiry for your case. So do not renew your passport if you are pending asylum applicant. Next question, can I grow them? Can I show them my I-7? Oh, okay, that's the same person. I-797 USCIS application along with my alien number. Please help me. Again, I don't know how Indian consulate works, so you better contact the Indian embassy and find out what you need to show them to be able to renew your passport. That's not something I can help you with. Next question I have is, hi, I'm from Washington State. Hi, nice to meet you. Next question, I have pending asylum and I feel looks need too long time. So do you think I have to make mendemes? No, I don't recommend filing mendemes action in every asylum case. In fact, I recommend filing it very rarely, because once you file mendemes action, I have seen personally, again, theoretically, that should not be the case, but in practice, I have seen cases that are denied outright and being sent to the immigration court. Now, if we dig deeper, probably the USCIS Asylum Office will provide some reason why they didn't schedule an interview, but it happened in at least 2 cases that I'm aware of where they did not schedule an interview and sent the case to immigration court after the mendemes action without having the applicant an opportunity to be interviewed. So, and it also costs a lot of money. And if you don't, filing mendemes action doesn't mean your case is going to be approved. It's going to be decided. It's going to be reviewed faster. They still have to do the background checks and so on, but they'll schedule your interview most likely faster if you file mendemes action. But again, it's just a human factor. Legally, they cannot deny your case or refer it to immigration court just because you filed the mendemes action. But in practice, unfortunately, I've seen that happen. So depending on the strength of your case, how confident you are, how strong is your case, then may be a good idea. Next question is, how long it takes for I-730 to get an interview after documentarily qualified? There is no specific timeline. Unfortunately, just as with many other things with the U.S. consulates, the I-730 interviews, I-730 is the asylee sponsoring his or her relative, meaning immediate relative, spouse, or child under 21. And once the asylee is granted asylum here, if they have a spouse or child abroad or here, and for some reason they were not included in the case, it may take several years. And usual experience is about a year or more until the I-730 interview is conducted and they're given the boarding foil, which is equivalent of visa to enter the United States. So if there is a reason to expedite, if there is a fear, or if there is dire economic situations or some other humanitarian emergencies, you can ask to expedite the interview. To do that, you would contact the consulate and send them directly this expedite request. There is a chance they can do so. The other option is, if those relatives, if your spouse or child, whoever you're sponsoring, has their own basis for asylum, their own basis for fear of persecution, they can also use the CBP-1 app and enter the US through Mexico and go through that 730 process here. That's basically another way of being paroled into the United States. Unfortunately, in some situations, because of these significant delays, a lot of applicants end up having to resort to this CBP-1 app and enter the US through Mexico, albeit lawfully, but it's a hard process because it takes so long for the I-730s to be processed and to be scheduled for interviews. Is it possible to cancel asylum case once I file it? If yes, can I withdraw my asylum case anytime? Give me some details. Okay, I'll give you some details. It's almost like a demand. All right. Yeah, it's possible to withdraw your asylum case. Whether it's a good idea or how you do it depends on at which stage and where your case is. If your case is in front of the asylum office, you can withdraw your asylum case by sending an email with a notice and with your signature. So you can attach a document notifying them that you would like to withdraw your asylum case. Now, the issue there is that if you do withdraw it and you're still in the US, or if they believe you're still in the US, they're going to transfer your case to immigration court for the removal proceedings. So do not withdraw your asylum case thinking that you will withdraw and everything will go away. No, you will be placed in removal proceedings if you're still in the United States. Or if you already became, for example, a permanent resident or got some other kind of lawful presence, whether it's parole, humanitarian parole, or you got TPS, then make sure to notify the asylum office by providing that evidence together with your withdrawal so they don't refer your case to immigration court. Now, if you're considering withdrawing your asylum case in immigration court, that's not that easy. It's not about just withdrawing. You will have to file, either get a voluntary departure or get the government to agree for a joint motion to terminate your case in immigration court. I just had a consultation with someone who entered the US with CBP-1 and is going through the process of asylum through immigration court, and they got selected for the diversity visa lottery. They actually got selected even before, but they got scheduled for an interview at the US consulate in Kazakhstan, and now they're deciding what to do. And the process of wrapping up the court process, the immigration removal proceedings in immigration court, is not as easy as just withdrawing your asylum case. The other important caveat for withdrawing asylum case is that if you are planning to withdraw it because you married with a US citizen, for example, or if you're going through some other process, do not withdraw it. Do not listen to false advice that many individuals give, including, unfortunately, some immigration attorneys, that you must withdraw your asylum case for your case to go forward. Or another wrong advice is that if you withdraw your asylum case, basically it goes away, it's never going to haunt you. Whatever you put in that asylum case is never going to be questioned. That's not true. Even if you withdraw your asylum case, whatever you wrote, whatever you provided in your asylum case will always be an issue, will always be considered, even if you withdraw it. Number one. Number two, if you're applying for permanent residency, for example, through marriage with a US citizen or whatever else you may have, withdrawing asylum case is not advisable. You don't have to. You can still get your permanent residency and have your asylum case pending. In fact, many don't know this, and I repeat it almost in every session because of this type of questions. you can be a permanent resident and you can have a green card and you can still apply for asylum and qualify for asylum, because those are absolutely two different things. Permanent residency is a permission to live in the US and work in the US, to permanently live in the US, but it doesn't give you any protections. You're still citizen of your country, and whenever you travel outside of the US, you're traveling as a citizen of the country of which you're citizen of. But if you get asylum, you're not only allowed to remain here and work and live in the US, but you're also given protection by the US government. The US government protects you as a refugee. And when you travel abroad, you get a travel document which substitutes your passport, which tells the rest of the world that you are the subject of the United States. You are under protectorate of the United States as a refugee. And you also get to enjoy some of the benefits for which, for example, permanent residents may not qualify, such as Social Security benefits or some kind of federal programs and so on. Because asylees are protected as refugees and because that's a humanitarian benefit, you do qualify for those benefits. So the public charge rule does not apply to asylees. That's why I do not recommend withdrawing asylum in almost any case. In very rare circumstances, I do recommend withdrawing asylum case. If you have a very weak case, or if you think that you provided some information which may be interpreted as false or fraudulent, then obviously you want to withdraw your asylum case. But be careful doing so, and don't do it without an attorney. Don't go through this process of applying for another benefit, withdrawing your asylum case without a qualified, experienced attorney handling it for you. It's almost like doing a heart surgery on yourself without going to a doctor. If you screw it up, there is no way back. You may be permanently barred from ever becoming a permanent resident or asylee in the United States. It's a very delicate process, okay? So, next question. Can you assist me to relocate to the US via tourist visa? I am from Nigeria. So, no, I cannot help you to relocate with a tourist visa. Our law firm can help you or any other individual in the world to apply for a tourist visa if the purpose of your visit is tourism, if your purpose of your visit is visit in the US. But when in your question, you're indicating relocating to the US, a tourist visa is not for relocating. If you do plan to relocate, you're not allowed to apply for a tourist visa. That's prohibited. And we as immigration lawyers are not able and allowed to help you to apply for a tourist visa, knowing that you're planning to relocate in the United States. Now, if you truly intend to visit the US, the process of tourist visa application is a detailed and thorough process. A lot of times people make mistakes. They just apply for a tourist visa, they get denied, and then they decide, okay, let me talk to a lawyer and see what I did wrong. But maybe the lawyer is going to help you then, but you already damaged your reputation. You already got denied once. It's rare that the consulate is going to reverse, even if you hire a lawyer and then give you a tourist visa after that. It happened. We have been able sometimes to fix that and get people approved for a visitor visa. But if you're applying for the first time for a visitor visa, you're starting from scratch, make sure you pay very close and thorough attention. And it doesn't refer just to you. I'm sure many of you that are watching this video, are asylum applicants in the US, or they're in the US, they have relatives, they have parents, and you're thinking about applying for a visitor visas for them to enable them to come and visit you here in the US. If you're doing this, do not just file a random application as a try to see if they'll get it or not. Make sure you pay thorough attention, respect the process, go through every step, work with a qualified immigration law firm to do this, because at the end, if it's denied, then you will regret it. So you want to make sure that you are thoroughly prepared, or whoever is applying is thoroughly prepared for the interview. All of the documentation is properly provided. All of the forms are properly filed for the visitor visa. Okay, the next question is, are cases won when asylum is filed based on the conditions in a specific country instead of personal attack on an applicant? All right, so what this question means is that, if the country conditions are really bad in one country and the applicant is a citizen of that country and comes to the US, although nothing happened specifically to that applicant himself or herself, can they qualify for asylum? The answer is yes, it's possible, though it's much more difficult. So this is called the future persecution case. So to get asylum, you can qualify for asylum based on the past persecution or future persecution. And although these terms sound complicated, I'll simplify it for you. Past persecution means that in the past something happened to you. That's why when you apply for asylum here, if you can demonstrate because of your race, religion, nationality, or membership in a group or political opinion, you have previously been harmed, then it's likely that you have a reasonable chance to be harmed now if you were harmed in the past. So that's why it becomes easier to prove asylum. But what if nothing happened to you in the past? Then what you can do is you can show the conditions in the country. You can show that you are in the group of those individuals who are being persecuted, whether it's political opinion. For example, everybody who has this type of political opinion and openly expresses it, they are being targeted. Look, so many people got targeted in this country, and I am from this country, and I have similar political opinion, and I have expressed my opinion. Therefore, if I return, I will be in the future also targeted. That's called future persecution. Or, it doesn't have to be political opinion. For example, I was talking today with someone who is a member of LGBT community in Russia, and, we all know that there are strict rules. There are not strict rules. There are actual laws against LGBT in Russia. There is public stigma against members of LGBT community in Russia, and not just Russia, some other countries as well. And, this individual was never attacked or targeted or harmed in any way, but now he's in the US and he says, well, because of this, what's happening to them there, if I go back, this will happen to me. Yes, that's a legitimate claim. It can work, but what was lacking for this specific individual is whether it is known, whether he came out, so to say, in the LGBT language, whether it became known that he is a member of that group. So, going back to political opinion, sometimes I'm asked this question, hey, I'm from Russia, for example, right? So I always bring up Russia because of the situation. There are many asylum applicants from Russia. So, somebody says, hey, I'm from Russia and I oppose this war, and people who oppose this war, this aggression towards Ukraine, are being persecuted in Russia. Give me asylum. I tell them, look, how do the government who actually does target those individuals who express their opinion about war, know what opinion you have? Just having an opinion in your mind is not enough. So the last element of your asylum qualification, the last fact that is missing in that person's case was that he never expressed his opinion. I said, did you ever post about your opinions on social media? No. Why not? Because if I do, I will be targeted. I said, well, you cannot have your apple and eat your apple. So if you have an opinion, if you express it and show that those who express this opinion have been targeted, then yes, then you can qualify for asylum. But just having an opinion and keeping it in your mind is not going to be enough. So anyway, I hope this answers this question, which is a very good question. If can you qualify for asylum purely based on the country conditions versus your specific harm that may have been caused to you. For those who joined now, please post your questions in the chat section. I will answer as much as I can. I will also briefly, in between these questions, I will describe and explain gathering evidence for asylum case, which will also refer to this question, this last question, which was a very good question about country conditions, what kind of evidence to use, and so on. So I'll describe the evidence for asylum case, which is an important topic. And I do want to remind you again, please subscribe to our channel. Please press like. Post your question in the chat section. And one of the other reasons why you should subscribe to our channel is because I made a very thorough video about gathering evidence and providing evidence in asylum case, which is one of the most important topics for asylum. Anytime you're presenting asylum case, the most important thing is you have to think about is the evidence, whether it's testimony, oral testimony from you, witnesses, documents, and so on. So I made a very detailed, about 1 hour video where I broke it down to great details, explained every step, types of evidence, how to gather it. And that video is going to be edited and posted on this channel. So if you subscribe to our channel and press that bell sign, the dark bell sign, I don't know what it does necessarily, but I think it actually gives you notifications when a new video is posted. So that will be very helpful if you do so. And again, I see that a lot more viewers than the likes. Please press like. Would greatly appreciate this. If you find these videos helpful, please do press like. So I will again answer as much as questions as I can. Please post your questions, and I will tell you briefly about evidence also in here in this live stream. So the next question I have is, I'm sorry, I kind of lost track of it. Okay, I withdraw my asylum question. I can go back. Okay, so can you assist me to relocate? I answered this. I came USA visitor visa, then I apply for asylum case after 5 years and no interview come in between. I married USA citizen, then USCIS give 2-year green card. Then question is, can I go back to my country, back to USA? Very good question, very relevant question. The answer is it depends on the basis for your asylum claim. So that's another mistake many people do. They apply for asylum, and while waiting for asylum, they get married to the US citizen, or they get green card through employment or some other ways. They withdraw their asylum case, right? Especially in this case, if you waited 5 years before you applied, you would probably not get asylum if you entered with a visitor visa because of the 1-year deadline issue. So you rightfully probably canceled your asylum case, but the fact that you withdrew your asylum case did not make it disappear. The fact that you claimed in your asylum case that you cannot return to your country still remains. Now, if you got your green card through marriage or employment, and as soon as you did this, or any time after that, before you became a US citizen, now you took your country's passport and traveled to your country, to the same country to which you said previously in writing to the US federal government, you provided your asylum application saying you could not go to because of the fear of persecution. So the question comes up, if you do so, to answer this question, if you do so, even though you're a permanent resident, if you travel to your home country after you withdraw your asylum application, then a legitimate question will come up, how come? What changed? You previously told the US federal government that you have fear of persecution. There is no way you can return. You will be killed, arrested, harmed, or something else will happen to you. Now you got your green card through marriage, and now you traveled back to your home country. What happened? What changed? Did you lie to us, or did the country conditions change? So, as long as you have a legitimate explanation, that can fix the issue. But again, by doing so, you're putting yourself in defensive. If you got through your green card through marriage, then within about 3.5 years or so, you can become US citizen. The reason why I'm saying 3.5 is because you can apply 3 months before your 3rd year of anniversary of green card, and you'll get your citizenship within about 8 to 10 months, approximately, sometimes more than that. So why not wait? Just wait until you become a US citizen so you don't create these unreasonable, unnecessary questions. Those are reasonable questions. The inquiries are reasonable. The US government should ask you why you told us you couldn't go and now you can go, So why do that? Why risk this? Don't travel yet. All right, next question is, hello, sir. If someone is on a visit visa and file for I-539 extension non-immigrant stay, the stay till the decision taking would be considered as legal stay in the USA. Yes, until the 6 months. So for the period of 6 months. So the visitor visa gives you 6 months of stay. And in your extension of stay application, you are asking for another 6 months. So anytime between the expiration of this status and the new 6 months you're waiting, as long as the USCIS hasn't made the decision, is going to be lawful presence. But sometimes USCIS takes more than 6 months to respond to your application, by which time the previous 6 months extension you asked already expired. So it may take USCIS 8 months to respond, right? So it doesn't extend another 2 months. You're lawfully present during the USCIS processing until the end date of the date that you requested for additional extension of your status. I know it's complicated, but if you ask for 6 months and that time is about to expire and the USCIS still hasn't decided your case, file another extension, or you're expected to leave the US because you only asked for 6 months extension. The fact that they didn't approve it yet doesn't give you time to stay here more than the 6 months. But all the time until they're processing the case, within the time you asked, is going to be lawful presence, and you can remain in the US until they make the decision. Okay, so I see a bunch of deleted messages. Slow mode is on. I don't know what that means. All right. Next question I have is, hello, sir. My husband applied for asylum and his case is still in pending. I got admission in USA. Can I get visa? Kindly help me how to apply and how many chances do I have to get visa? I don't understand. You know, the question says, I got admission in USA, and then it says, can I get visa? In the immigration terms, admission means you're already in the US. You already had a visa, you entered the US. That's what's called admission. Now, if you're talking about admission to school, and you're applying for a student visa and your husband is here filed for asylum, you're probably out of luck. Highly, highly unlikely you will get a student visa. Unfortunately, that's not going to be probably possible. Now, if your husband has filed asylum case and it's pending, and you have fear of persecution, you have some risk, you have some kind of fear in your home country, then you may be able to, you are able, I mean, I wouldn't say maybe, you're currently able to download the CBP app in Mexico, come through the Mexican border with the appointment with the CBP officer and join your husband's case. Now that CBP One app is valid and it's still working, but today we'll learn that I believe either Florida or Texas as a state sued the federal government trying to stop, in the federal court, trying to stop that CBP One app. So yeah, it's not, I don't think they're going to win this, but they may. It's not, you never say never, and it will, since it's going to be considered by the Supreme Court, who's majority conservative. So there is a risk that there may be a stop to the CBP One. If you are considering coming to the US, or if you have close ones, family members, or considering coming to the United States to apply for asylum or join your asylum case, do it now and go through this lawful, legal, and painless process. Do not pay anything to anyone, any organizations, any coyotes trying to, smuggle you through the border. Do not pay anyone to help you with CBP One app. It's a simple process. Just go to Mexico, download the CBP One, register, make an appointment, and you will be scheduled an appointment. It takes about a week or so, week or two, from what I hear from our current clients. And then you will have this appointment, and then you will go to the border and meet with the CBP officer. They will greet you. They will review your documents, let you in. 98% of the cases, there is no detention involved. There is no guarantee that CBP One is still going to be open in the near future. Next question I have. My asylum file was received from Office of Texas after my visa expired by 1 day only. That's because there was a weather bad condition. FedEx actually was late. So now I have a pending asylum. Okay, very good. So if that was not your fault, make sure you have the record that you mailed it within 1 year and that it was FedEx who delayed it. And I'm sure that will fall under the exceptions. Make sure you document it properly, Marwa, and use it in your case when you have the asylum interview. Oh, the question continues. And I want to apply for EB3 visa. Is it possible to get that? Well, depends on the circumstances. So you can go through EB3 visa if you have an employer. EB3 is employment-based permanent residency, basically employer who's sponsoring the beneficiary. So, it consists of several steps. There is Department of Labor processing, there is USCIS petition, and there is your green card application. So in most circumstances like yours, since you're saying that you applied after 1 year, I assume you already had status expired before that. Most likely the third stage, the final stage, you will not be able to do it in the US. You're not going to be able to file in the US for permanent residency, you will have to leave and go through US consulate. But if you have a pending asylum case, you can also get advanced parole to be able to leave the US with advanced parole as additional insurance in case if something goes wrong at the consulate, so you can return. And it also helps you not to lose your asylum case while you're going through this consular processing. But the short answer is yes, there are many ways to be able to qualify for EB3 permanent residency based on employment. You need to have an employer who's willing to sponsor you. And once you have that employer and they're willing to sponsor you, do contact us. You have our contact information, I believe, in the beginning of the chat section, and it will be also below. It's all over the internet. Just Google my name or I.S.Law Firm. Schedule a consultation with me one-on-one, and I'll go through each factor in your case, all of the circumstances in your case, and tell you what can be done. And if your employer wants to participate, whoever your EB3 sponsor is going to be, they can also participate. All right, next question is, can someone travel to his or her country after getting a green card by asylum if there is a change of government in that country? What are other conditions to travel to original country? Thank you. So yes, it's basically, I gave a very detailed answer about traveling to your country after you get asylum, or even after you withdraw your asylum. That question will always come up. Now, it doesn't automatically invalidate your asylum or permanent residency or cause issues of fraud, but it raises this question: how come you were able to travel to this country, although you claimed you couldn't in the past? Depends on the answer, depends on the circumstances, depends on the situation. And the change of the government, if your asylum claim was based specifically on this specific government targeting you, and you have some revolution or change in the government one way or another, and now things don't look as bad, then that's a good explanation, good answer. Be prepared for these questions at the border and when you apply for citizenship. But again, this question will come up if the officer at the border or at the USCIS at the time of your citizenship is doing their work diligently. They should be asking you these questions. The USCIS pick cases random, or do they work on strong cases faster? No, I actually think they're talking about asylum. So Abdul is asking, does the USCIS Asylum Office review for stronger cases and then weaker cases, or vice versa, or is it random? Because what we know is that the asylum interview scheduling is very chaotic. Right now, if you apply for asylum, you may be scheduled for an interview, highly unlikely, but you may be scheduled for an interview within 6 months or so, or you may be thrown into the backlog and wait for years. And I'll tell you this, I've seen both strong cases when you have the complete application with your declaration, documents, and everything, it looks good. They have scheduled interviews faster in those cases. And I've seen in those cases where the application is not complete, somebody filed it on their own, doesn't seem like they have a real case, it's been more than 1 year, there's clear 1 year deadline issue. I think there is some kind of system that they use. We have a meeting with the asylum division director in mid-June, and I will be participating there. And that's going to be one of the questions that I will be asking is, what type of system they're using. But yeah, it seems like when they see the case is very straightforward, whether it's straightforward because it's approvable or straightforward because it seems like it's just a random case somebody filed to be able to get a work permit, they will put obstacles, and they will schedule an interview as soon as possible for those cases when they see that somebody filed a case because they just want to get a work permit. There is no declaration, there is no legitimate information in the forms. It seems like, it's just a case for that. Next question I have, can we expect premium processing in F2A category in the near future? No, we cannot. There is no premium processing for any case that is in the visa bulletin. So F2A is a family category 2 family reunification, family-based petition. So the petitions premium processing is not going to help. It's not going to change. Even if they come up with a premium processing for family-based petitions, we're talking about not immediate family members. We're not talking about U.S. citizens sponsoring child, spouse, or parent. And we're not talking about permanent residents sponsoring, the child under 21 or spouse. But in the categories, in the petition process, in the family-based categories, the main wait time is the visa availability. Now, for permanent residents sponsoring, now that I think about it, the permanent resident sponsoring spouse or child under 21, that is a category in the visa bulletin which is current, but the significant delays in the petition processing. So I correct myself. I think that the Nomaan Khundmiry was asking about F2A permanent residents because it takes a significant amount of time for the petition. The answer is no, they're not talking about premium processing at all for family members. Not I-130s, no I-130s. I haven't seen any information about potentially expediting, potential premium processing for family-based categories that are focusing on the employment-based where EB cases and national interest waiver was recently, L1s were recent, well, not L1, EB1, executive or extraordinary ability, those are processed. I don't think so. I don't think there is even talk about family-based I-130 premium processing, basically. All right, the next question I have is, can I travel within USA with my real ID only while I am still waiting for my court hearing? Yes, you can travel within USA as much as you want. There is no problem whatsoever. Any travel in the US is within the US, and you don't need there is no immigration check in traveling within the United States. Next question. Hello, sir, please, what is the current processing time for I-730 from filing to interview? It's very vague. Probably about 1 to 2 years of processing, regular processing. If you have urgent humanitarian reasons, you can ask to expedite this. Next question I have is, I am from Bangladesh. Tomorrow I have individual hearing in court. I'm good in English, not fluent. I cannot understand me. So I prefer not to take. Do you mean you can understand me? Because you wrote, I can't understand you. So I prefer to not take interpreter with me. Is there any suggestion for me? Now, you cannot take an interpreter to immigration court. In fact, you can understand me. Okay, thank you. Yeah, you never take an interpreter to immigration court. The government provides an interpreter in immigration court, and you need to verify that with the clerk. Now, if you have an individual hearing in immigration court, I hope and I beg that you do have a lawyer who's representing you in immigration court. It's very, very difficult and very dangerous to go to individual hearing without an attorney. So find an attorney, hire an attorney. If you don't have one, I don't know, find a way, maybe try to get an extension. But if you don't or do, it doesn't matter. In terms of interpreter, if you can understand me, if you can communicate to this level, if you can express your thoughts, yes, if you can express your thoughts, if you can understand me, then you don't need an interpreter. Then you can express yourself, then do it. It will go much smoother. You don't have to, the interpreter loses, there is a tone of conversation in your answers. Sometimes interpreters misinterpret something. It all creates chaos. The hearing goes much longer. The judge gets frustrated. The immigration officer, if you have asylum interview, gets frustrated. So there is a wrong perception that you should have an interpreter. If you don't understand something, you can always ask them to repeat. And guess what? In the immigration court, in the individual hearing, if you have an interpreter, you can also tell the judge that, Judge, I feel comfortable communicating in English, but the fact that interpreter is very helpful in case if I don't understand or if there is a confusion, I will ask, or if we can do that way. So ask the judge. They appreciate it because they also don't want this hearing to be twice longer because everything you say or they say is going to be translated and so on. So work with them, talk to them, and see if you can have an interpreter as a standby and use English. They appreciate that. It helps. And you don't have to use any complex legal language. You don't have to use any difficult language. So And I apologize, I got something really urgent that came up. So I will answer as many questions that I have already there. If you want to post, you can post. I'll probably continue this for another 5 minutes. And again, we'll continue this every Thursday at 12:30 New York, Washington time, US Eastern time. We're going to have these, we do have these live streams. Please press like, please subscribe to our channel. As I said, a very detailed video about the evidence for asylum case is going to be posted on this channel. If you subscribe and click that bell sign, then you will be notified. It's going to be very helpful if you are considering applying for asylum, or if you applied for asylum, or you know someone who applied for asylum, you have a pending asylum. This video is going to be extremely important and helpful for you. And if you found this live stream helpful, if I answered your questions, you found it helpful, please press thumbs up, like. That will significantly help us. So the next question I have is, if I'm from Bangladesh, okay, I answered this. Is there any special cases for pilots who came to the USA by visitor visa to get a work permit? There is no special case that I know of for pilots, but usually pilots from I haven't done the national interest waiver for pilots myself, but I know that a lot of pilots qualify for national interest waiver if you have some significant achievements, if you're well positioned to advance because of the shortage of pilots. Plus, because of the shortage of pilots, you can probably get an employment-based permanent residency, although if you're here on a visitor visa, you don't have enough time to wait for the adjustment of status in the US. If that pilot has FAA approved pilot license, yes, that's obviously is very helpful. FAA, thank you, stands for Federal Aviation Administration. So that, here's my recommendation. It's very specific, depends on the experience, background, consult with an immigration attorney directly. Now, if you're thinking about scheduling consultation with me on this topic, don't. I'll be honest with you, I haven't handled national interest waiver cases or employment cases for pilots specifically. And I know that there are some attorneys that kind of like specialize on helping FAA licensed pilots for the either national interest waiver or extraordinary or employment-based O1 visas and so on. So yes, there are some special ways. They're not like special ways, but there are ways to get that done. So consult with some attorney who has done this, Google or see if somebody has thorough information about that. Okay, so I see that admin also posted the link for scheduling a consultation with me. Please use this. Again, thank you so much for joining. Please press like if you found this live stream helpful. Please subscribe so you'll be notified. Other than these live streams, we also post lots of videos, lots of brief videos about news, changes in immigration laws. If you have asylum case pending, or if you're planning to apply for asylum, or if you know somebody or your close one who filed for asylum or planning, please subscribe to our channel so you will be informed. And again, please press like. Thank you very much. It's been a pleasure. Bye-bye.